Thanks everyone for coming along today, and thank you, Becky, both for the invitation and for the kind introduction. As some of you will see, I am sporting a nice sling, and I am a little bit too familiar with the accident and emergency room of the Alfred. I had an inaugural interaction with the tram lines of Melbourne 10 days ago, so if I wince or yawn, it's nothing to do with the content of my presentation, rather, nursing a rather sore broken collarbone, but I'll try my best. I'm very excited to be here, as Becky said, presenting on an interdisciplinary area of socio-legal studies. So before I get started, I suppose I just want to explain who I am and how I got to this particular issue. I think because it really brings into focus how multifaceted this area is and how complex it is. Not to say that these issues are intractable, but how important it is that we have conversations both within and between disciplines and between and within the university and practice more broadly. I'm a criminal lawyer, but latterly I've been involved more and more in projects that look at problems of crime that cannot be solved by criminal law, essentially. So I've been involved in a collaborative project with two criminologists in Europe looking at how legal structures like trusts, companies and other ostensibly legitimate relationships are used as mechanisms to both create and conceal illicit assets. So in other words, how do we get the capital for and the profits from crime? How are those kept? And how can we then, as socio-legal scholars and as criminologists, think about how best to respond to these particular problems? So I'm a criminal lawyer who's reluctant to use the criminal law, or is, I think, duly skeptical of how effective the criminal law can be in addressing some of these issues that situate themselves, or are situated rather, in somewhat grey areas that can seem ostensibly legal, but are certainly morally or problematic or socially problematic as such. So I got chatting to Becky when I arrived in Melbourne in September last year and realised that there's some really interesting conversations to be had in this particular space, and this is some work that I've been doing in relation to one of the Sustainable Development Goals in particular, namely the issue of illicit financial flows. And as a lawyer, I suppose I'm then interested in what exactly are we going to do about this? We might have identified a problem, we might try to measure the problem, but then essentially, should we be introducing more laws? Should we be enforcing the laws that are in place? So really this is what I'm going to try to grapple with today, and I'm also then trying to contend with the fact that I think we have maybe a range of expertise and backgrounds in the audience. So some of what I do at the beginning of this presentation will be the bread and butter or nuts and bolts of some people's work, but for me certainly was novel when I started to explore this area. So be generous and please bear with me as I bring you through the Sustainable Development Goals before looking at the crux of the problem for me today. If I can get the PowerPoint to work. Should this be clicking? Okay, so wonderful, thank you very much indeed. Okay, so the Sustainable Development Goals, as I said, I'm preaching to the choir here. I know many people will be very familiar with this, but what we have essentially until 2030 is an extremely ambitious global development plan, and we have 17 goals and just under 170 different indicators and targets that are the manifestations of these particular goals, looking at economic prosperity, social development and protection of the environment. And for me, my particular interest lies in goal 16 and in a particular component of that essentially. So goal 16 is going to be, I suppose, familiar to the lawyers in the room, these concepts of gaining access to justice for all, as well as building effective and accountable institutions at all levels. But what we'll see if we drill down further is that these targets are rather more fine-tuned, and if the link will work, we can see that as well as there being a particular goal, we then, and this is the case for all of the goals, have particular targets and indicators. So my interest particularly lies in 16.4, which does set a rather ambitious aim of significantly reducing illicit financial flows as well as arms flows, then strengthening the recovery of stolen assets, as well as combating all forms of organised crime. So there's a great deal going on here, and I really just want to drill down further into this notion of illicit financial flows in particular. You'll see then, and I'll allude to this in a little bit more detail in a moment, that there are particular indicators of the attainment of said goals, and then if we scroll back up, and people will be able to look into this in a little bit more detail, the tabs here that we can see progress and information in respect of each of these goals and indicators on an annual basis. So it's a remarkably ambitious and a remarkably important plan of action agenda for movement, and I want to, as I said, drill down into 16.4 particularly, and see exactly what is being done, what could be done, and what do we as lawyers, or what can we as lawyers contribute to the attainment of this particular component of this particular goal.
Would you like a hand?
That would be wonderful. So for the PowerPoint, I feel I'm gaining dexterity in my left hand, but it's the rotation, the mobility is not ideal. So if we're back to, here we are. So again, thinking about how comprehensive, how the breadth of the ambition really is really striking, and it's a sub-part of 16.4 that I'd like to spend today speaking about, namely this idea of, in the first instance, ascertaining what an illicit financial flow is and how exactly then we can start to try to address the problems with that, and in so doing attain better attain sustainable development. So this is, again, just to reiterate the different components of 16.4. My attention today is going to be on illicit financial flows, and we can see there are indicators already in place, which one could argue, I think, are narrower than one would hope in some respects, insofar as one indicator will be trying to ascertain, to the extent that is possible, the inward and outward illicit financial flows in a global sense in different jurisdictions, and then the next sub-indicator pertains to arms, so I won't be focusing on that. But we can see that 16.4.1 has a remarkable amount going on in it, and certainly there are issues both of quantification as well as of definition in both the legal and broader sense that require to be addressed before we can ascertain whether there is positive movement towards these indicators or not. So what I want to do today is really threefold, to focus in on the notion of definition. So I suppose this is my lawyerly inclination, that if we are seeking to ascertain what progress is being made towards the attainment of Sustainable Development Goal 16.4, that we need to really have a thorough conversation as to what illicit financial flows might mean, what it might exclude, what's contestable or ambiguous about these definitions, and what our definitional choices may well mean in respect of Sustainable Development Goal 16.4. Moving then from definitions, I'd like to try to outline the playing field essentially at the moment, what has been done to date in terms of the operationalising of 16.4, what initiatives have been introduced on a global level, and then also alluding in particular to Australia and other individual jurisdictions that may well help in bringing this part of 16.4 to fruition or improving its attainment. And then I suppose what I'm going to try to do finally is to move past the critique that can be maybe the luxury of academic commentary in this space, to say, well, if I have misgivings about the definitional components, if there are concerns about the operationalizing of this particular target so far, what might we do as researchers, as scholars, that could help in bringing these aims to fruition in a richer, in a better sense. And then hopefully we'll have time for questions afterwards. So this matter of definition really is not just a matter of semantics. It's of critical importance as to how exactly we determine what illicit financial flows mean. I think what we need to do here is really to parse the concept. And there has been a great deal of debate, both in the scholarly sense as well as internally in UNODC, for instance, as to whether illicit maps onto criminal or unlawful, or whether it is rather broader. And our choice in this respect isn't just one of academic luxury, rather it is going to be absolutely vital in terms of what is encompassed both in the measurement of the attainment of the goal, but then in also what kind of initiatives we see as included in realising its particular purposes. So as I said, deriving from pre-existing work that I've done in this space, my positing is that it's important that this concept is not just limited to criminal matters, not only to unlawful matters, but also to matters that are sociologically harmful. And so drawing on semiological insights as to the harm that's caused by particular acts, or the harm that's caused by particular actors, to my mind is critical in this context. The downside of taking such an expansive approach is that some would say, well, it dilutes the very meaning of what is included, and in fact, the contestability of criminality has the benefit of clarity, so that is to its merit. But to my mind, especially given the harms that have been emerging from the Banking Royal Commission here, and we can think of a range of other examples worldwide, limiting it to criminal matters, to my mind, is overly narrow and moves away from what the Sustainable Development Goals are about, which is both harm to and benefit to particular communities and particular jurisdictions. So that's something we can maybe discuss further in questions, which is this notion of where the parameters would lie. And this matter of definition is important, as I said, because it has a knock-on effect in terms of how we measure the attainment of the goals, but then also what we include as an initiative to seek to remedy any of these particular harmful acts. As an aside, I would add that initiatives on a global scale in respect of addressing corporate crime, like deferred prosecution agreements, the negotiation that goes on with corporates and so on, ensures that a lot of harmful behaviour, and Commissioner Haynes spoke about this in his report, will never actually reach the criminal courts, and they may never reach the criminal standard of proof. So we have various layers, I suppose, in the hierarchy, and various thresholds that are extremely difficult to surmount. So if we take an interpretation of illicit to be akin to or mapping onto criminal, we are in an unfortunate manner, I would argue, excluding a great deal of problematic behaviour. So illicit is something that ought to be interpreted in a broad sense. So this is, as I said, something that is being toyed with at the moment. Certainly there's been a number of expert group meetings within the UN on how to measure the attainment of this Sustainable Development Goal, and this discussion is ongoing, so it's an unresolved, a contested issue. But to my mind, the problems that emerge from an expansive approach are not so problematic as to warrant taking a more legalistic criminal law focus. The other component, I suppose, that is not clear from the Sustainable Development Goal itself and is important to reflect upon is, well, when we're speaking of illicit, are we talking about the illicit nature of the particular assets, or of the people that are involved, or of the acts that are involved? And some would argue, and I think there is some clout or some merit to this claim, which is that, well, assets can't be illicit. Assets are assets. They may derive from problematic behaviour, but they are, in fact, in a value sense, neutral in and of themselves. And that, in fact, what we should be reflecting upon is the purpose for which the assets are created and maintained, or the purpose for which they're used, or the criminality or harmful behaviour of the particular actors involved. And indeed, again, this is a debate that has been studied within the UN expert group meetings. Are we speaking of illicit activities that might result in a conviction, so taking a formalistic criminal law legalistic approach, or are we taking a broader harm-based approach that I would advocate, and then hinging the illicit nature to the criminal or harmful actors rather than the assets themselves? So these are complex issues that are certainly not going to be resolved over this lunchtime and are not resolved in the UN setting either. So it certainly remains to be seen, given that there's going to be a more lengthy analysis of the attainment of Sustainable Development Goal 16 later this year. It would be interesting to see how, or indeed if this is resolved, but this is certainly ongoing. So again, I'm advocating an expansive approach in saying that the illicit classifier or qualifier is something that can pertain to the finances, so the assets, the flows, as well as to the people involved. And another point I would refer to here, and I'm going to come back to at the end, is critical to a lot of this are professional enablers or professional facilitators. So again, we have this veneer of licit behaviour or veneer of legitimacy, but a lot of this illicit flow of assets is enabled by virtue of the connection to the kind of legitimate professional world, and that's something I think would be lost. The focus on that would be lost were we to take a legalistic criminal law approach that would look at assets only. So I'm taking I'm proposing, I suppose, a not uncontroversial, expansive approach in this context that has been contemplated within the UN, but is not yet resolved. The next matter of definition that again has a knock-on implication for both measurement as well as for the likely and potential responses in this space is this notion of financial flows. So we know the Sustainable Development Goal itself does allude to arms flows also, but here I'm interested in financial flows. So this is something that's maybe less controversial, which is, well, what exactly does finance mean in this particular instance? Are we going to take a relatively broad interpretation of that? And this seems less controversial. So a notion of money, other kind of property assets, and so on. So I think we can maybe park that as being uncontroversial or less problematic. The final component, and again, I'm mindful of how an expansive approach can potentially either dilute the definitions to a large extent, or can also make our task even more onerous in seeking to attain these particular goals. But I would urge a note of caution in the focus on financial flows. And there's been some really interesting work by Brooke Harrington, for instance, on the potential of trusts to keep assets static, essentially. So what we have in the UN is a focus at the moment, very rightly so, on the movement of assets in and out of particular jurisdictions. So that could be a relatively well-off country with a low tax rate like Ireland, for instance, where you have particular companies being located to benefit from tax arrangements and assets moving in and out with a disproportionate and artificial impact on GDP measurements, or countries in the global south which really see none of the benefits of assets that are moving in and out very rapidly. But I think again we must be mindful of the fact that there are particular legal forms and structures that mean that money isn't flowing and it isn't moving. So there's a possible blind spot if we are to focus on flows that again we as scholars I suppose have the luxury of focusing upon in saying, is there something about the lack of movement of assets that could well also be problematic and illicit. So we have, I wouldn't like to say, a kind of an infinite number of subcomponents that we need to reflect upon, but I think what ostensibly seems like a relatively straightforward part of one subpart of a Sustainable Development Goal really has a lot of key dimensions that have to be thrashed out and have to be analysed in a deeper sense. So there's been a number of expert group meetings within the UN as to these matters of definition, and it remains to be seen how the fuller analysis later this year resolves or addresses these issues. But to date, these matters are not finalised or are not resolved. So that's the definitional component, and I think, as I've tried to allude to so far, that these are not just legal matters or matters of theoretical or conceptual interest. They have dramatic practical impacts in terms of how exactly we're going to measure these, what indicators we will use to measure attainment or otherwise of this particular sub-goal, and then in turn what we're really going to try to do about the attainment of this sub-goal. So, again, just to remind you, we have one indicator that says the total value of inward and outward illicit financial flows will be attempted to be measured. And as I said, we have these matters of definition. So whether we are defining illicit as meaning criminal, unlawful or harmful just has an absolutely astronomical effect on what is included in these matters of definitions. And then of course we have issues of how and what to measure, issues of sources, and this is going to be familiar with anyone who's operated in the socio-legal or criminological sense about how do we measure crime, how do we measure harm, and so on. And this is not to be fatalistic or unduly pessimistic, but just to flag up the fact that there are both definitional and methodological issues that really remain to be resolved. So the UN, various agencies itself, I thought this was a pithy but rather helpful quote in saying that this is a methodologically challenging but highly relevant topic, which I thought, well, that's pretty generous and something that's really been causing me a great deal of grief in trying to ascertain whether or not this is an intractable problem, whether or not we can actually try to measure how this, as you can, I'm saying Sustainable Development Goal 16.4 in practice, but it's only a subset of that particular goal in practice. Are we going to be, after the in-depth analysis later this year, still saying that it's methodologically challenging but highly relevant? So we have no agreed definition to date on what illicit financial flows are. We don't have any official data collected at present, although, as I said, there's been a couple of UN expert meetings on the statistical measurement of illicit financial flows, but really what this is doing is mapping out how we may well come to some firmer definition and what kind of methodologies might be possible. What we do have are from a number of different non-profit, non-governmental agencies such as Transparency International, the use of Sustainable Development Goals 16.4 and other cognate ones as the starting point for particular questionnaires or both quantitative and qualitative mechanisms for both oversight groups as well as governments themselves to start to try to figure out how these particular goals are being worked towards, if not resolved completely. And it's interesting, again, Amy, can I ask you to click on that link if you wouldn't mind? So hopefully people will get a chance to look at the slide. So this is a really remarkably in-depth questionnaire. And what it does is it asks questions about various matters such as anti-money laundering compliance, the transparency behind the ownership of companies, whether or not there's a register behind trusts, and so on. And obviously for Transparency International, transparency and corruption are the kind of animating factors under this. Thanks, Amy, just to, yeah, people get a sense. So it's a detailed, full document, as I said, that goes beyond 16.4, but it's still useful for us to get a sense of how 16.4 has been used as a political lever, political with a small p here, I suppose, in this particular scenario. So if you don't mind flicking back to the PowerPoint, thank you. Where this leaves us, I suppose, is with the question of whether or not there will be a comparable UN endorsed or UN created document with a comparable list of questions to seek to address this particular, as I said, relevant but challenging initiative. So one of the things that the Transparency International questionnaire does, as I said, is to allude to what you might call cognate initiatives that are not necessarily required by or proposed by the UN or by either international or soft law, but which Transparency International sees as relevant to the attainment of these particular goals. And this is going to loop back to the definitional component, because what we include here is going to be relevant to whether we're taking a formalistic criminal law approach or a more broad-based semiological harm-based approach. So Transparency International, for instance, in this questionnaire speaks about, well, what kind of anti-money laundering schemes are in place in your jurisdiction? What kind of registers are in place for companies and trusts? And very much is focused in that space. That said, if we broaden our focus to say, well, ostensibly legal but potentially harmful behaviours, such as in the tax context, would mean then, well, we would also be thinking about, well, what about the in-country reporting of profits by different companies, whether that's Amazon or Google or Apple and so on and so forth. And what about the exchange of tax information? Because a lot of this is operating in the allegedly legitimate sphere, but it can have harmful social effects. And so where we set the line in terms of what is illicit will determine which of these initiatives we deem to be relevant in responding to the particular issue. And again, this is something that the UN expert meeting is live to and has focused upon, but it's not yet resolved. And certainly because of matters of time, I'm not going to be able to focus on all of these. I want to focus in on just one, but it's just worth recalling that how we address our definitional question then is going to impact which of these we deem to be relevant. Because if we are saying, well, a lot of this annual reporting of in-country profits, all of this is entirely illegal, so why would this be relevant to 16.4? Whereas if we take that semiological approach, we maybe would be more generously inclined towards having such matters included as this then we would see in that kind of over more expansive approach. We would see this as relevant in attaining these particular goals. So beneficial ownership registers are an interesting case in point in that there has been a global dynamic towards increasing transparency as a way of offsetting illicit financial flows, or as I said, even illicit financial creation and maintenance. So the money may not be going anywhere, but it can still be illicit, it can still be problematic. So we've seen in the EU, we've seen in Hong Kong, we've seen in certain states in the US, we've seen an increasing drive, notwithstanding some questionable empirical basis for this, that increasing transparency by virtue of revealing who is the beneficial owner of a company is going to offset the misuse of said companies. And we've seen a comparable approach in respect of trusts. Shed the light of transparency on what is going on through the Panama Papers, the Paradise Papers, and so on and so forth. And this will both reveal the problematic behaviour and potentially deter such questionable behaviour in future. And as I said, there's been some work that I've done with colleagues, Jason Sharman and others, that have said, well, these beneficial ownership registers are static, historical, hard to verify, very expensive to run, of questionable effect, but nonetheless, transparency has attraction. It's very hard to fight with this notion or to dispute the appeal of this notion of transparency. And of course, you have Transparency International, Global Witness, other entities as advocates for this approach. And it's striking that this beneficial ownership register is part of Transparency International's, one of their measures essentially for the attainment of Goal 16.4. So whether we see the UN also advocating such a measure, I think it would be an interesting case in point. It's not required by the Financial Action Task Force, which is the main global soft law is even debatable, policy maker essentially in the anti-money laundering space, but beneficial ownership registers are required by the EU, for instance. And there's been some really interesting discussion here in Australia. So it felt like there was a transparency juggernaut essentially, and that one was nearly speaking heresy by virtue of disputing their what was happening in Australia before I arrived last year. And you can see Kelly O'Donnell saying, well, we need to improve transparency because it's going to prevent the misuse of companies for illicit activities, and this could be tax evasion, money laundering, bribery, corruption, terrorism financing. So again, really speaking to the core of the harms of these criminal illicit financial flows. And then we have maybe a little bit more skepticism from Chris Georgian saying, well, it could be a lot of good, but it might just be a lot of stuff that doesn't really help us. So Peter Aldridge in the UK has spoken about anti-money laundering resulting in us all drowning in data, essentially. So I think this is where the skepticism came from, that we may have a lot of information that could be sifted through, like in the Panama Papers, for instance, but given the questionable validity of this information, we maybe have a bit more skepticism about this. And then just a couple of weeks back, we have this remarkable about turn, whereby the coalition here then abandoned the plan for a beneficial ownership register and said, in just striking sensing, no, it was never on the agenda. It was never something up for debate at all. So this, for me, I suppose, is striking. That's something that is advocated in the EU. Certainly, there's a great push in the UK for the British Overseas Territories to incorporate such measures. Transparency International, unsurprisingly, is advocating this measure. That this is seen as a key component of the response to these illicit financial flows, that nonetheless there has been, I think, a degree of trepidation about its introduction in Australia. So it remains to be seen whether this plan just vanishes into the ether, or, as the FATF would advocate, that there are other mechanisms whereby we can reveal who's behind an illicit financial flow other than a register. It might be more onerous, might be more expensive, but it's going to be of much more benefit in an either deterrent sense or then in a kind of after the event law enforcement sense as well. So it's a rapidly moving space, and as I said, I only have the capacity in terms of timing and focusing in on this one particular area. But there's I think a degree of uncertainty as to, well, what's the core of the problem that we're trying to address? What exactly would success look like in this space? And there's a great degree of unsurprisingly, politicking going on here. So finally, to wrap things up with the last couple of slides, really this got me to thinking, well, as an academic, it's fine to sling tomatoes at the plan going on here, bows and arrows, and criticize what's going on. What can we do if we feel that there is merit and value in Sustainable Development Goal 16.4, if we recognize the harms and if we feel that the movement should be in a positive sense forward? What exactly can we do? So to my mind, there needs to be, in a scholarly sense, a deeper understanding in particular of the professional facilitators and enablers that are allowing such behavior to occur. Because if we're thinking about the legal or regulatory arbitrage that goes on, whereby we would have a company maybe in Jersey that then is owned by a Scottish limited partnership, and we have chains of ownership going from jurisdiction to jurisdiction, also then using particular structures in particular ways. None of this is being concocted on the back of an envelope. This is sophisticated stuff, and what we've seen in particular of interest to me in the UK is the impact of legal changes on the choice of particular structures that are used. So when company law was tightened up in the UK to require there to be one human person as well as a legal person as a partner to the company, the use of Scottish limited partners shot through the roof, and now there's been a crackdown on those. It's Northern Irish partnerships. So this is subtle and contemporary legal knowledge. So this is happening within spheres that I think maybe for some it's unpalatable to shine a light upon. So we really need to look at and develop a deeper understanding of what particular structures are being used and why, what third parties, what professional enablers are allowing that to be done. And as I said, what sometimes is called unintended consequences, but it's something that lawmakers are maybe not best placed to do, and us as scholars it's incumbent upon us to do, which is to say that a lot of these legal and policy changes aren't neutral, that there can well be an impact on the criminal choices or the illicit choices that are made. So our choice to alter whether it's the criminal law or the regulatory landscape can have a knock-on impact on the way criminal acts or illicit acts are actually perpetrated. And of course then this still then is back to the problem, well, if we're going to develop a deeper and richer understanding, we're still thinking of that matter of how exactly do we respond to that. So to my mind, what we need to do in the first instance is perhaps resign ourselves to the fact that the definition of choice won't be uncontroversial, but that clarity is what we can hope for, that we need to confirm what the parameters are. As I said, I would suggest that the risk of having an expansive definition I would be happy to weather those risks essentially, because the consequence of excluding ostensibly legitimate actors and what might be seen as tax avoidance rather than evasion, for instance, is going to is going to exclude a range of problematic behaviour. This then, I suppose, is where I'm going to pass the buck or pass the baton to my colleagues in other disciplinary contexts, such as criminology, economists and so on and so forth, to think about what methodologies for measurements are best. And then importantly, in a softer sense, to think about how we, either as scholars or then as advocates, as political activists, can think about how 16.4 can be used as a lever for political change, whether that's sounding a note of caution in respect of beneficial ownership registers perhaps, but also then advocating better enforcement rather than more law, for instance. The last 3 bullet points, I suppose, is maybe where I feel a little less positive, or maybe I'm a little bit more fatalistic, insofar as we have, some would say, an intractable tension between particular market dynamics in the global sense and jurisdictions. Again, I'll use Ireland as a jurisdiction that I'm familiar with, and I always wince when I hear of it as being being deployed in such manners, in such a problematic sense, but that there are both market imperatives and political imperatives about situating jurisdictions as a hub for business, as seeking to attract business, for instance, with these particular sustainable development goals. This is a problem, I suppose, that runs throughout the financial misconduct and anti-money laundering spaces, is that we have a situation whereby those that are being policed are also the policers. So you have essentially this notion of self-regulation. So the banks are both trying to monitor their own money laundering and perhaps also in some respects benefit from that, or at least ensure a degree of blindness to it. And finally then, and I think this is exemplified by the beneficial ownership register example, we have an inconsistency between political rhetoric and practice. Again, what's so new, what's so big, people would say, but I think the extent to which we need to really face these issues head on is important for us, I think, as scholars. So I'm going to wrap things up just by saying this hopefully will be a fuller chapter for an edited collection that Jared Blaustein, who's in criminology here, is pulling together. I'm going to be writing that with Nick Lord, who I've collaborated with in the past, and we've a couple of both co-written and solo pieces looking at, well, in the cognate space, how are legitimate forms used in a way that help create and conceal these illicit assets. So I'll wrap things up, hopefully with time for questions. Just thank you for your attention. Thank you for your patience and generosity with the respect to my injury, and I look forward to hearing your comments. So thank you.